The prosecution proved that a public admission was made. It did not prove that a plot existed. And the prosecution's own position is that it does not need to. Those three sentences are not a contradiction. They are the case.
Magandang gabi. Iyon ang boses na maririnig ninyo buong gabi. At bago tayo magpatuloy, kailangan naming linawin kung kanino iyon. Before we begin, to be absolutely clear, our guest is an AI-generated character. He holds no office, he is not a judge, he has never sat on any court. Nothing he says tonight binds anyone or decides anything. This is analysis of the public record and nothing more. Ako si Mon Villarasa, kasama ko si Ate Jorbea Santiago. Fictional AI hosts din kami, pero totoo ang record na binabasa namin.
Ang tawag namin sa kanya ngayong gabi ay Justice Emilio Bantayan. Hindi siya totoong tao. Walang tunay na huwes na may ganitong pangalan. Sinadya yon. Ang trabaho niya dito ay isa lang, sukatin ang record laban sa batas at sabihin kung saan tumutugma at saan hindi.
16 na araw ng paglilitis, 4 na artikulo ng impeachment, 16 na boto ang kailangan para mahatulan. At ngayong gabi, hindi kami ang magsasalita tungkol sa ebidensya. Siya.
Justice, isang tanong bago kayo magsimula. Hindi po ba kayo maghahatol?
No, and I want to be precise about why, because it is not modesty. A verdict is an act of authority. I have none. The court that has it has not ruled, and it should not be crowded while it is still hearing evidence. More than that, a verdict would tell you less than what I can actually give you. So, I will not say guilty. I will not say not guilty. I will not tell you how I would vote. And I will not predict how anyone else will. What I will do is this. For each article, I will state what the record establishes, what it does not, what the standard actually requires, and where the gap between those sits. That is a finding. It is narrower than a verdict, and it is more useful.
Simulan po natin sa Article 4, ang tanging artikulo kung saan tapos na ang prosecution.
That is the correct place to begin, and for the reason you just gave. Article 4 charges culpable violation of the Constitution, high crimes, and betrayal of public trust. It is the only article on which the prosecution has rested. Every other article is still being presented. You cannot make a finding about a case that is still being built. You can only make one about a case that has been closed. So, this is the one article where the question is fair to ask. First, what the record establishes. The video is authentic. It was forensically examined and it was not generated by a machine. That mattered enough that the defense itself admitted its authenticity. When both sides agree a thing is real, it is established. The investigating bureau found probable cause to recommend criminal complaints for grave threats and for inciting to sedition. Its institutional assessment was that this was no longer merely a threat but a plan. Serious, active, continuing. None of that is in dispute. On this element, the record is not thin. It is solid.
Justice, iyon po ang panig ng prosekusyon. Ano naman ang hindi nila napatunayan?
Now, the other half. And I am going to give it to you together with the prosecution's answer to it, in the same breath, because to separate them would misrepresent the record. What the record does not establish, no contract was ever produced. No specific person was ever identified as having been hired. One investigator admitted on cross-examination that he had no personal knowledge that anyone was contracted at all. After 1 year and 8 months, the list of persons of interest had been narrowed to fewer than 20. Narrowed, but not one of them named. That is a real gap, and I will not soften it. But here is the prosecution's answer, and it is not an evasion. Their position is that the case does not hinge on proving an assassin existed, or that a murder plot was carried out. Their theory is that the betrayal of public trust was complete the moment the admission was made in public. On that theory, the missing hitman is not a hole in the case. He is outside it. So the honest finding on Article 4 is not that the case is strong, and it is not that the case is weak. It is that the case rests on a legal theory rather than on a manhunt. If the court accepts that a public admission of that kind is itself a betrayal of public trust, the evidence is there and it is largely undisputed. If the court requires proof that the threat was operational, a contract, a name, a payment, then the record does not contain it, and the prosecution has already said it does not intend to supply it. That is not a gap in the evidence. That is a disagreement about what the provision means. And that question belongs to the 24, not to me.
Justice, ang Article 1 po ang pinakamalaki. 612.2 milyong piso na confidential funds. 7 kaaraw ng testimonya.
7 days of testimony, and it is the deepest record in this trial. It is also the record I can say the least about. Let me explain why. Because the reason is the finding. The prosecution has not rested on Article 1. It is still presenting its case. And the most recent witness, the officer who handled the disbursements, had not been cross-examined when the court adjourned. She was still on direct examination. Testimony that has not been cross-examined is not evidence that has been tested. It is one side's account, given under oath, and nothing more yet. It may survive cross entirely intact. It may not survive it at all. Neither of us knows, because it has not happened. What I can say is what is on the record and not in dispute. A very large sum of confidential funds was released. The officer who released it cited a joint circular as her authority. She was asked to point to the provision in that circular that permits a security officer to spend confidential funds. She did not point to one. When the question was narrowed, she answered that disbursing is the disbursing officer's job. That exchange is on the record and it is significant. But note what it is and what it is not. It is a failure to identify legal authority in the moment of questioning. It is not, by itself, proof that no authority existed. And it is not proof of where the money went. Those are 3 different propositions and they are constantly collapsed into one.
So paano po ninyo tatapusin ang Article 1?
I do not finish it. That is the point. The finding on Article 1 is that it is the most substantial record in this trial and the least settled. It is rich, it is detailed, and it is half-heard. Anyone telling you tonight what Article 1 proves is telling you about a case whose second half has not been presented. I would need to see the cross-examination completed before I would say anything further. That is not caution. That is the order of proceedings.
Article 2 po, unexplained wealth.
On Article 2, the record contains a ruling, not evidence. The court ordered bank tax and anti-money laundering records produced. The bank and anti-money laundering records run from 2007 to 2025. The tax records do not. The court cut those off at 2021 because the defense correctly invoked Section 71 of the tax code. That 4-year difference is not a detail. It is one of the limits. The court applied a stated test. The documents had to be reasonably described, readily identifiable, prima facie relevant, and material. It included the spouse, on the reasoning that with no prenuptial agreement the property is held in common, and that net worth cannot be measured by looking at half of a shared estate. And it imposed 3 limits, which have been widely ignored in the discussion of this article. Foreign currency deposits were excluded entirely. The tax records, already cut short at 2021, may be used only to establish a baseline for measuring wealth in office, not to prove new offenses. And the anti-money laundering material goes to the presiding officer privately before it goes to the parties. So the finding on Article 2 is short. Documents were ordered produced under a stated legal test with 3 express limits. No witness has been examined on them. A subpoena is not proof. It is permission to look. As of the 16th day, no one had testified about what was found. There is nothing yet for me to weigh.
At ang Article 3 po.
I have nothing. I do not mean the evidence is weak. I mean the record before me does not tell me what Article 3 even charges. No witness in the material I reviewed testified to it. Its existence is known because the court ruled that the prosecution must present evidence on all 4 articles. So there are 4, and this is one of them. I will not guess at its contents. A judge who fills a silence with an assumption is not doing the work. The honest statement is that the record before me is silent, and that is the whole of it.
Justice, huling tanong. Ano po ba talaga ang kailangan para mapatalsik ang isang opisyal?
That is the question almost nobody asks, and it is the only one that decides anything. Impeachment is not a criminal trial. Nobody goes to prison at the end of it. The penalty is removal from office and disqualification from holding another. That is why the standard is not the criminal one. This court is not asked whether a crime was proven beyond reasonable doubt. It is asked whether the conduct proven is the kind of conduct that makes continuing in office intolerable. 16 votes. Not a majority of those present. 16 of 24. The number does not move if senators are absent. That is a deliberately difficult threshold, and it was made difficult on purpose. So let me end where a finding should end, with what I would need to see. On Article 4, I would need the court to first decide the legal question it has been avoiding. Whether a public admission of that kind, standing alone, is a betrayal of public trust. Answer that, and the evidence question answers itself. On Article 1, I would need the cross-examination finished, not a summary of it, all of it. On Article 2, I would need one witness, any witness, examined on the documents the court ordered produced. On Article 3, I would need to be told what it says. Until then, anyone who tells you this case is finished is not describing the record. They are describing their hope.
Salamat po, Justice. At paalala sa lahat, si Justice Bantayan ay AI-generated na karakter. Hindi po siya tunay na huwes, walang opisina, at walang jurisdiksyon, walang binding na desisyon dito. Pagsusuri po iyon ng pampublikong record, hindi hatol.
Kayo pa rin ang huhusga, 16 na boto ang kailangan sa Senado. Pero sa comments, isa lang ang boto ninyo. At gusto naming marinig iyon. Ang korte ay nag-a-adjourn. See you at the next session.